Under traditional principles of negligence, a person owes another the ordinary duty of care that a reasonably prudent person would exercise under similar circumstances. However, in some states, common carriers, or those who transport goods or passengers for a fee, owe their passengers an extraordinary duty of care to protect them from injuries. In the 1998 case Bethel v. New York City Transit Authority, the Court of Appeals of New York considered whether a passenger who was injured on a New York City bus was owed an extraordinary duty of care. On June 19, 1989, Mark Bethel boarded a New York City Transit bus in midtown Manhattan. Upon boarding, Bethel proceeded to a seat directly opposite the rear door. The seat was wheelchair accessible and could be folded up by a lever to create space for a person in a wheelchair to be strapped against the bus's sidewall. But at the time, the seat was in its normal horizontal position, available for ambulatory passengers to sit on. As Bethel sat down, the seat collapsed, sending him to the bus's floor, severely injuring his back. Following the incident, a transit authority inspection revealed that the position of the seat was at a slightly elevated angle and that the seat couldn't be restored to its normal horizontal position. In fact, in the inspector's attempt to adjust the seat, a hinge broke and the seat collapsed. Subsequently, Bethel sued the transit authority in New York Supreme Court based on negligence. At trial, Bethel couldn't prove that the transit authority knew the seat was subject to collapse and instead relied on a theory of constructive notice. At the conclusion of evidence, the court charged the jury that, as a common carrier, the transit authority had a duty to use the highest degree of care in maintaining its vehicles and equipment for passenger safety. Further, the court submitted to the jury the question of whether, considering this extraordinary duty of care, a reasonable inspection would have led to the discovery of the seat's condition and its repair. The jury found in favor of Bethel solely on the basis of constructive notice. The transit authority appealed the decision, and the appellate division affirmed. The transit authority then moved for permission to appeal, which the Court of Appeals of New York granted.